Hi, my name is John McKenna. I'm a partner here at Macri Harvey. Today I want to talk to you about Britney Spears, of all people. Unless you haven't heard, she's going through some legal troubles in California where she's had a conservatorship appointed for her. Her father is her conservative, and recently the judge appointed a bank to be a co-trustee or co-conservator. Here's the problem. Conservatorships are very similar, if not the same, as guardianships here in Pennsylvania. When you are found to be an incapacitated person in Pennsylvania, a guardian is appointed for you, and that person could be a guardian of your person and your estate. What's important to understand about this is that the guardianship, as well as the conservatorship, is never permanent in nature. What that means is that it's always subject to the review of the court. So you can always go into the court and say, hey, you know, I'm feeling better. I'm not as confused as I was. I'm not undergoing the same trauma or psychotic episodes or whatever the case may be. And I don't need a conservator or a guardian anymore. In Britney's case, she applied to the court and said, hey, you know, I don't think I need a guardianship or conservatorship anymore. I'm better. I want to handle my own affairs. The problem is that the court has never said that she doesn't need a guardian. What it said was, we're not going to let your father be the guardian alone. We're going to appoint a bank to handle the financial affairs. The same thing can happen in Pennsylvania, although I think our courts are a lot more responsive in terms of review hearings and making sure that the person is properly cared for. So if you're ever appointed a guardian, take these ideas to mind. Number one, that you have to file a report every year as to what you're going on. Number two, those reports are audited by the court system. Number three, if they find some irregularity, they'll call you in the court. But also number four is if you're doing a good job and you're filing your reports on time, you know, you are basically going to be liability free. The court also most likely will require a bond that will be paid for by the assets of the guardianship. So like Britney, I don't think she would be treated much differently than she would in Pennsylvania. However, she also probably wouldn't have as much TV coverage and paparazzi following her around like they are here, which probably led to some of her problems, that she was never left alone. They always harassed her. There's one little postscript to this whole story, and that is, especially in Pennsylvania, some of this can be avoided is at the time you are capacitated, say, if you execute a power of attorney, giving a trusted person, somebody that you choose to be the person who cares for you physically as well as economically, that's probably the better way to go. Certainly when you have a power of attorney, that person can sign checks or do things when you become incapacitated, and you have some control over it. You can always change the power of attorney. You can change the person that you want to be power of attorney. So there's a lot of reasons to do this, because it avoids the expense that can happen when you go to court and you have to get a psychiatrist or a psychologist or some medical professional or psychological professional to testify as to your incapacity. Certainly, if you're at a time when you are capacitated and you appoint somebody, you won't have to go through that trouble. So that's a real important lesson from this one. I don't know if Britney ever had a power of attorney, but if she had one now, she would have a little bit more control over what that person does. So I'm not necessarily for or against the Free Britney crowd, but I think a little understanding of how our system works is important. So thank you for your time, and if you need any more help, just let me know. Thank you.